Why am I the only one in here?
Good morning. Today is September 28, 2023. It's approximately 9:30 in the morning. This is the matter of the application Z0277-23-Z. It's an application for a zone change on a couple of parcels of property. My name is Carl Cox. I'm land use hearings officer for Clackamas County. I'm a private attorney. I have a statement to read and a couple of housekeeping matters. This is a quasi-judicial land use hearing, which means two important things for those participating in this hearing. First, all of the criteria that can be used in reaching a decision have been identified in the staff report. Testimony, arguments, and evidence must be directed towards the criteria identified in the staff report or other relevant criteria found in the comprehensive plan or other land use regulation that the person believes applies to the decision. Accordingly, please direct your testimony to a relevant approval criterion. Second, failure to raise an issue accompanied by statements or evidence sufficient to afford the decision maker and the parties an opportunity to respond to the issue may preclude appeal to the Oregon Land Use Board of Appeals on that issue. Failure of the applicant to raise constitutional or other issues relating to proposed conditions of approval with sufficient specificity to allow the local government or its designee to respond to the issue precludes an action for damages in circuit court. Once final, this decision may be appealed to the Oregon Land Use Board of Appeals. I have considered issues of bias and conflict of interest and have determined that I do not have any bias or conflict of interest in this matter. I've also not received any ex parte contact, meaning no one contacted me outside of these proceedings to try to persuade me concerning a fact or issue present in this hearing. I have reviewed the application and the exhibits that were submitted to the county that are posted on the county's public website, and Ms. Fritzy provided a copy of the PowerPoint she intends to present at today's hearing. This hearing is being recorded. The county is making a record that is available through the county. And at this time, I will ask that the county provide an explanation concerning participation in the hearing via the Zoom platform. Please proceed.
Thank you. Good morning. This public hearing will be conducted virtually using the Zoom platform. Panelists for today's hearings, which include the hearings officer, county staff, and the applicant, have both audio and video capability. Audience members who join the meeting will have their mics muted unless they wish to testify, in which case they will be called upon to do so by the county staff moderator. Audience members' videos will not be turned on at any time. Today's hearing is being recorded as required by state law. The county will make every effort to post the recording on the county website later today. There is a designated time during the hearing when it will be open for testimony. The hearings officer will make it clear when this is. If you want to provide testimony, you will utilize the raise hand feature. Attendees on PC and iPad, you have a raise hand button on the Zoom bar, top or bottom, depending on your device. When the moderator switches you over to provide testimony, your screen will look different for a little while. Primarily, you will see all the participants' cameras, not just the one who's speaking. Staff will call upon you when it's time for you to provide testimony. Be sure to provide your name and mailing address when you begin. Once you've provided your testimony, your mic will be muted and your screen will be returned to normal. If the record is left open at the end of this hearing and you wish to submit additional written testimony, email written testimony to me, Martha Fritzy, at mfritzy@clackamas.us, or mail it to Clackamas County Planning and Zoning Division at 150 Beaver Creek Road, Oregon City, Oregon 97045. The staff contact email address is also available on the web page where you found the Zoom link for today's hearing. Testimony must be received by 4 p.m. on the day the record closes. People who testify and provide their mailing address will receive a copy of the hearings officer's written decision. If you do not wish to testify, but would like to receive the decision, you must provide your email or standard mailing address either by email to the staff contact, me, for this application, or by entering it in the Zoom chat function during the hearing.
Thank
That's
you.
it. Mhm.
The order of proceedings will be that I will ask the county to begin the hearing with a presentation of the staff report, and I understand there's a PowerPoint presentation associated with that, followed by an opportunity by the applicant and the applicant's representatives here to supplement that and provide information, additional information for me to consider with respect to the application for this zone change. Then there will be an opportunity for members of the general public to provide testimony or commentary for me to consider in making a determination concerning this application. I may also provide opportunities for rebuttal or opportunities for the answering of questions. Are there any questions before we begin? Use the raise hand feature. And also when you were called upon to provide comments or testimony in this matter, please clearly state your name and your role here. For example, I am Carl Cox. I'm the hearings officer. Ms. Fritzy is the representative for the county. Members of the public may just call themselves a concerned neighbor or citizen. That is fine, or area homeowners association or what have you that determines your role here. All right, please begin, Ms. Fritzy.
Thank you. All righty. Why is this not starting? Ah, there we go. Can you see the cover page? Okay.
Yes.
All right. Hi. Thank you. Good morning. I'm Martha Fritzy with the county's Planning and Zoning Division, and I am the staff person who was the primary person to review this proposed zone change. And I'm going to do my very best to go through an overview of the staff report and the findings fairly quickly. It is long. There's a lot involved here, so I'm going to apologize ahead of time. I will do my best to go quickly, and I'm certainly happy to answer any questions that may come up if I skip over something that you think is important or if it's confusing. So today we are here to talk about the proposed zone change under file Z0277-23. Before we get started, Mr. Cox did mention that there were some new exhibits that he had received. There are 3 new exhibits, 2 from neighbors and 1 from the attorney for the applicant that were received after the original packet was posted. I have sent them to the hearings officer. I've also uploaded them to the Acela website where the public can access them. A couple of them were just this morning because they came in last night. Exhibit 17, you'll notice is missing there, is just the PowerPoint that I'm giving today. It is important to note that the local community planning organization is the Hamlet of Beaver Creek. They have not to date submitted any testimony, but I do expect that they are here today and will provide some oral testimony and maybe some written testimony follow-up. So as I mentioned, this is a proposed zone change. The proposal would be to change the zoning from the existing farm forest 10 acre or FF10 to rural area residential or RA2. It's important to keep in mind that this is just a zone change. The comprehensive plan designation is not changing for both of those zoning districts. The plan designation is rural, which is a really short way of saying rural residential. Both of these zoning districts are rural residential zones and allow residential development. This zone change in and of itself would not authorize any specific development. If the zone change is approved, the applicant would then have to come in and file for a subdivision and then subsequent development permits. So the zone change is really just changing what is allowed on the property. It's not actually specifically authorizing any development. What it would be doing would be authorizing, would be increasing the development potential of the site from about 11 lots that currently could be It currently could be divided into about 11 lots under its current zoning, and under the RA2 zoning, there would be a potential of up to 55 lots for detached single-family homes. The subject site is located about just under a mile south of Oregon City, just under a mile sort of northwest of the unincorporated community of Beaver Creek. It contains 2 tax lots, approximately 111 acres total. It's bound on the west by Highway 213. It includes these 2 lots. Lammer Road right here touches the eastern boundary of the site. And you can see the zoning itself is FF10. The surrounding properties are zoned FF10. There's a fair amount of rural residential 5-acre zoning in this sort of darker taupe. There's closest RA2 zoning is about a half mile northeast. And then, of course, the unincorporated community of Beaver Creek also has some 1-acre zoning. So there's a lot going on here. The green areas over here are natural resource zones, farm and forest zones. So there's a lot of mix of uses and different zoning types in the general vicinity of the subject. This is an aerial photo. The subject is sort of separated into 2 parts. Each tax lot's a little bit different. The larger tax lot to the west is relatively flat. It does have a wetland, and there was a wetland delineation provided by the applicants that identifies this wetland area generally along this line here. It encompasses a total of about 0.89 acres of this 82-ish acre site. The other site up here is a little bit different. It has Beaver Creek traversing through it. Beaver Creek is it's a fish-bearing stream. It's regulated by the county's zoning and development ordinance. This part of the site is more heavily treed. It also does include some steep slopes going down into the Beaver Creek Canyon. And so when we are looking at the potential to change the zoning of a property, there are a lot of criteria. The staff report is posted as Exhibit 1. It includes a lot of detailed analysis of all of the relevant criteria. The most relevant criteria are listed here, including these various statewide planning goals, certain zoning and development ordinance criteria, and county comprehensive plans and goals. I'm going to highlight the most relevant ones. Again, the staff report and the applicant's narrative contain a lot more detail about each of these relevant criteria. And so the very first thing that we need to think about when we're looking at changing the zoning in rural residential areas is statewide planning goal 14, urbanization. So generally, statewide planning goal 14, urbanization, talks about urban growth boundaries and what we sort of intuitively would consider really urban development. But there is a specific section in administrative rules listed here that addresses how the application of goal 14 specifically to rural residential lands, and it provides us direction about whether or not an exception is needed to goal 14 to change the zoning. It's important to note that even if under that specific rule there is no exception needed, case law further tells us that you still need to determine whether or not the proposed use is urban or rural, because any urban development on rural lands requires a goal 14 exception. So there's sort of 2 pieces to this analysis of whether or not this property needs a goal 14 exception before we can even really consider the zone change. And so OAR 660 Division 4, Section 40 requires a minimum lot size of at least 2 acres for new rural residential areas. And it's a specific rule that came about back in 2000 and 2001 that DLCD, the State Department of Land Conservation and Development and the Commission were concerned about what was going on in rural residential areas. And they created some new rules that established this minimum 2-acre lot size and established some criteria specifically for addressing rural residential zone changes and development. But at the same time, they recognize that some jurisdictions were already acknowledged to comply with Goal 14. And it's important to note that Clackamas County was one of those jurisdictions that was acknowledged to comply with Goal 14 at the time. And so this rule identifies when an exception is required. And the specific language is listed here. And the important thing to keep in mind is that there are actually differing interpretations of this goal exception requirement. And there is, in fact, a decision by the Land Use Board of Appeals in 2007 that specified that they believe that this specific rule is referring to an amendment to allow smaller lot sizes, but does not refer to an existing acknowledged zoning ordinance that already allowed the reduction. And I'm just paraphrasing that. The important thing to keep in mind here is that there is this differing opinion. The DLCD has submitted comments, which are included in Exhibit 4, that they believe a Goal 14 exception is required. And the reason largely is that they believe that this decision that I was referring to in 2007 in Curry County does not apply to Clackamas County, that it created a specific carve-out that doesn't apply to Clackamas County. County staff has consulted with County Council, the applicant and the applicant's attorney, and in fact, a hearings officer all have reviewed this this material before related to other zone changes, and concur that Goal 14's exceptions are not always required for rural residential zone changes, and in this particular case is not required, largely because the county was acknowledged to comply with Goal 14 at the time that the rules changed, and also because the process that is the process and criteria to change the zonings within rural residential zones has not changed in the county's code since then. And really what is proposed under the applicant's proposal is really not functionally or substantively different than what had been proposed by Curry County in that 2007 decision. And so county staff finds that under this specific administrative rule, this proposal does not require a Goal 14 exception. Further, I mentioned there's two parts to this. When you're looking at a Goal 14 exception, you also do need to look at whether or not the proposed development would be considered urban or rural. Goal 14 specifies that 1 acre lots are urban, 10 acre lots are rural, but it really leaves a little bit open in between. There's really no bright line for lot sizes in between, based on various case law and LUBA decisions. It needs to be looked at on a case-by-case basis. But there are several factors to consider, including the provision of public facilities and services and whether or not they're needed for the development, potential impacts to a nearby urban growth boundary, whether or not the use is appropriate for and limited to the needs of the rural area, and the intensity of the use. Based on those factors, both the applicant and staff agree that this proposed use is rural and not urban, and therefore under this analysis, it would not require a Goal 14 exception. And so based on both of these two parts in Goal 14, we find that a Goal 14 exception is not required. The other statewide planning goal that I listed on that previous slide is Goal 12, and that has to do with the transportation system. I'll talk a little bit more about that later in the context of some other criteria. So once we determine sort of at a high level that a goal exception is not needed, then we need to look at what criteria are required for a zone change. And our zoning and development ordinance, section 1202, and specifically 1202.03, outline the criteria that are required for a zone change. There really are four main criteria, A through D. Under A, it specifies that the proposed zone change is consistent with the applicable goals and policies of the comprehensive plan. So that kicks you back into the county's comprehensive plan. So Both staff and the applicant assessed the policies in the comprehensive plan. There are a number of relevant policies. Really, there's 5 chapters in our comprehensive plan that had policies that needed to be addressed. Chapters 2 and 11 really are largely procedural and coordination. They have to do with the process, including this public hearing and giving the public opportunity to participate. And all of those applicable processes have been followed. Chapter 5 relates again to transportation, to the transportation planning rule, specifically goal 12. I'll talk about that again in a little bit more detail, but a transportation study has been submitted, and both ODOT and county's transportation and engineering staff have agreed that that study did show compliance with the transportation planning rule, excuse me. And so then we get to chapters 3 and 5. And so chapter 3 of the comprehensive plan has to do with natural resources. I mentioned that there is a mapped wetland on this property. There's also a stream corridor and some steeper slopes around that stream corridor. And so we look at the specific policies in chapter 3 related to those specific natural resource areas. The most notable one is 3.F.1, which specifies that when you're looking at a change like a zone change or any pretty substantial development, you need to prevent disturbance of natural wetlands. And so this policy really was originally adopted into the comprehensive plan because the county didn't have really good mapping outside the urban area. So in the rural area, we didn't have good mapping. And just to make sure that we were compliant with statewide planning goal 5 for wetland resources, it's a safeguard to make sure that this is looked at in detail when we're looking at substantial developments or in proposed zone changes. And so in this case, there is a mapped wetland on that larger western portion of the subject site. It encompasses just under an acre. DSL has concurred with that mapping, meaning they've agreed that what was identified is the wetland areas that exist on that property. And the applicant, through a number of items, has demonstrated that new development could occur on this property outside of those wetlands. And specifically, they provided a conceptual plan that identifies that the lots and the home sites and the septic areas could all be developed outside of the wetland areas. They've provided an elevation showing the type of bridge that would span the wetlands so that roads would not be developed in that areas. They've provided a report completed by a civil engineer related to drainage that found that each 2-acre lot can infiltrate runoff from any new assumed impervious surfaces, assuming a general or a typical type of residential development on a 2-acre lot. And then finally, they have proposed and agreed to comply with a condition that any future land division through any future land division, they'd be required to place the delineated wetlands in some sort of development restricted either area or tract, which would further, which as a practical matter would put a line on a map where development could not occur. And so that's how it would be protected. Another policy, 3.L.3, talks about applying appropriate safeguards to development on wet soils. Again, it references a specific resource, the Bolton 99 maps. That map did identify some wet soils on that western portion of the property. Again, they line up generally with the wetland. The important thing to keep in mind with the Bulletin 99 maps is that they are a resource, and they in the Bulletin 99 document, it specifies that this is not intended to replace an on-the-ground assessment of what's going on. And so in this case, even though Bulletin 99 sort of generally identified some wet soils, its staff finds it's pretty safe to conclude that the wetland delineation is a more accurate and detailed and on the ground identification of where those wet soils are. There's one other policy in Chapter 3 that I didn't actually list on the presentation. It has to do with protecting river and stream corridors. It's a little bit different than the policy about wetlands. It really talks, it uses the term, you know, to the extent, to the maximum extent practicable. You have to protect these areas. It's important to keep in mind that when I talk about the stream corridor of Beaver Creek, that is a protected area. Our zoning and development code prevents development within 70 feet of that stream, and also has some vegetation preservation requirements. And so within that 70-foot buffer, there is no development allowed. The applicant has actually proposed another condition of approval, which creates a little bit larger buffer around that stream than our zoning code requires. And they've proposed a 100-foot buffer and also no development on any slopes over 20%. And so that is one of the recommended conditions of approval, but that's also one of the ways that we can ensure that these natural resource areas are protected as much as possible. So Chapter 4, land use, really sort of gets to the issue of what plan designation and what zone can be established where. And so in this case, policies 4.mm.11.1 talk about where the RA2 zoning can be applied. And so there's really, there's 6 criteria listed there. The last one's not applicable to this property, so I'm not going to talk about it. I'm going to talk about these 5 criteria in sort of small chunks. The first 2 being that the parcels are generally 2 acres or smaller, and the area is significantly affected by development. I think it's pretty clear from the aerial photos that this area is significantly affected by development. It's clearly surrounded by subdivisions with lots that are a lot smaller than 2 acres. In fact, some of them are as small as 8,000 square feet. There's a golf course across the street. There's churches, a distillery, a veterinary clinic. And furthermore, within a quarter mile of the subject property, this idea that parcels are 2 acres or smaller has been interpreted to mean just the simple majority. And in this case, 72% of parcels are smaller than 2 acres, which is clearly larger than half, than simple majority. And furthermore, over 80% of those parcels are developed. And then the last 3 criteria talk about no natural hazards, topography and soils suitable. There must be a public, or excuse me, there's a typo. There must be a public or private community water system. And RA2 can only be applied to areas in proximity to or adjacent to an unincorporated community or an incorporated city. As I mentioned, this site is about a mile or just under a mile from the city of Oregon City and also from the unincorporated community of Beaver Creek. There is public water available. Clackamas River water serves this area, and as well as the surrounding rural areas. And regarding hazard areas, this property does not contain any mapped landslide, mass movement areas, or floodplain. There is some steep slope on the site. It will not be developed. It'll be within a future restricted development area. All same thing with the wet soils. The remaining soils, based on the applicant's information provided of the soil types, seems to be suitable for development. It's listed as well drained. And so all of the rest of those criteria can be met. And as such, that was a lot, but this proposal is consistent with all the relevant comprehensive plan policies and meets that first main criteria for zone changes. And I promise the rest of them will be shorter. So sub B, the second criteria, requires that if there are any needed public services, that they are available and sufficient for the development that would occur under the new zoning designation. There is no public sewer. All of the individual lots would need to have their own septic or subsurface sewage disposal areas. There is public water service, and we have received a preliminary statement of feasibility from Clackamas River Water that they could serve the potential new number of new lots, as well as we have received a statement of feasibility signed by the Surface Water Management District that the surface water management could that the surface water could be managed on site with the proposed zone change. And so that's really how we address this criteria here, is that we know that the services can serve what is proposed under the new zoning. And so finally, the last two have to do with the transportation system, C and D, and really have to do both with the adequacy of the transportation system and whether or not the zone change would meet goal 12 and the transportation planning rule, and then also with the safety of the transportation system. And so a transportation study, a traffic impact study was provided by the applicant. And the applicant also has worked pretty closely with ODOT to understand what might be needed on Highway 213. The proposal would be a new access point off of Highway 213, right around the center of the site, roughly, I think, across from where the Stone Creek Golf Course has an emergency access. ODOT has reviewed this, and obviously a development permit would be required from ODOT, but so far has concurred that that would is something that they think they could approve. The transportation study looked at whether or not the proposed change would meet the transportation planning rule, which has to do with the adequacy of the transportation system. Both ODOT and the transportation and engineering staff confirmed that that this proposal would meet the transportation planning rule, although both agree that mitigation is needed to address the safety of the highway. And specifically, there's 3 items, and these are listed as potential conditions of approval. One is that a left turn lane be installed on southbound left turn lane on Highway 213 approaching the site access, this new site access. There needs to be a storage length of 100 feet for the southbound left turn lane, and also that there be a right turn deceleration lane northbound on Highway 213 approaching the site access. So, in summary, the staff finds that this proposal does not need an exception to statewide planning goal, and that with conditions that are listed on page 3 of the staff report, the proposal meets all the applicable zone change criteria, and therefore staff is recommending approval of this is the wrong file number, 277-23, subject to the recommended conditions of approval, including those Highway 213 modifications, and including that future development will be prohibited in delineated wetlands, slopes over 20%, and within 100 feet of Beaver Creek. Sorry for that typo. That's it. That's me. My contact information is listed down here, and I will probably correct that typo and re-upload this as Exhibit 17 for the public.
Thank you. I'd like to provide an opportunity for the applicant to supplement the information provided by Ms. Fritzy and the staff report concerning this application for a zone change.
Certainly. Thank you, Mr. Cox. My name is Garrett Stevenson. My address is 1211 Southwest 5th Avenue, Suite 1900, Portland, Oregon, 97204. Representing the applicant in this case. I've got only 3 things I wanted to cover very briefly, and before I get started, I want to thank Martha for the very comprehensive staff report and explain that our approach to this particular application has been to exceed minimum standards, as Martha mentioned, with respect to protection of sensitive areas and wetlands on the site. That was something that the county had some substantial concerns about when we came and tried this once before. And we came back with a different plan that we think does a far better job protecting those resources and actually exceeds the minimum standards. And I'll speak about that in just a moment. The first thing I want to cover is, and I'm not going to say too much about it because I think both Martha and myself have covered the issue substantially in writing. But the question of whether a Goal 14 exception is required was raised by DLCD. We originally addressed that question in our application. Martha addressed it in her staff report very comprehensively. And then I provided additional explanation about that Curry County case in case you find that helpful, Mr. Cox. But basically, the theory is there. From my understanding, the methodology that the county uses to determine whether one of its rural residential zones should be zoned 10 acres, 5 acres, or 2 acres was adopted in the early 80s. The Curry County case, the original Oregon Supreme Court Curry County case came down in 87 that basically established, if memory serves, the principle that whether something's urban or rural is on a case-by-case basis. I'm not necessarily sure that that case has any bearing on the county's code, simply because, again, the county's code in this regard predates that original 1987 Oregon Supreme Court case. And at least in my view, I think the question of whether use is rural or urban is resolved by whether or not the application meets those criteria in section 4.mm.11.1 subsection A in the comprehensive plan, which, as Martha explained, we do meet. The later 2007 Curry County Luba case basically, I think, was very simple. It was decided on collateral attack principles. Basically, in that case, Curry County wanted the ability to downzone property from 10 acres to 5 acres. That would be prohibited in the same way that a downzone from 10 or 5 to 2 acres would be under the Division 40 rules that were adopted in 2000. And Luba properly said, no, this has been on the books in Curry County since long before these 2000 OARs took effect, and we're not going to disturb that right now. Those rules did not have the effect of unacknowledging any comprehensive plan that would have allowed use of 5, 10, or 2 acre zones prior to that time. And again, in Clackamas County's case, these rules have been on the books for a long time. And I believe that that is the basis upon which the counties, and I don't know whether it was you, Mr. Cox, or other hearings officers, but I know of at least 2 other cases where the county has come to the same conclusion for similar applications of 5 acre zones and so forth. So unless you have any questions about that, I'll move on to the next topic.
No questions about that.
Okay. So the next thing I wanted to cover, and is it okay, Mr. Cox, if I share my screen? I wanted to talk a little bit about our access proposal here.
Is this a submitted exhibit, or will it
be? It is, yeah. This is from our application. It's an exhibit to the application, and I can actually tell you which one. It is Exhibit 2, page 4 of 7 to our application narrative. And I zoom in on this. There was a question in some of the testimony about whether we would need to acquire right-of-way. And just to step back, the proposal is, and this is something that we worked out with the county and ODOT between our last proposal and this one. And the original proposal would have had access coming onto Mitchell Lane here. That is no longer the proposal. The current proposal is a new access located here. Again, we've worked with ODOT on this, and this includes a left turn lane here, and then a deceleration lane, like a right turn lane here, and then acceleration lanes here. And I don't believe there's an acceleration lane going to the south, although Mike Ard may correct me on that. The point is that we looked at this, we developed this plan with both county and ODOT participation, and we do not need additional right-of-way beyond our own property to build this. That was one of the things we wanted to make sure of. And across here is an emergency access to the golf course. It's not shown on the plan, but what the county and ODOT have asked us to do is place our access point across from there, just to coordinate driveways. but I just want to make sure the record is clear that this is something that we do not need to acquire additional property to build, and something that both ODOT and the county support at this point. The last thing I wanted to cover, and I'm going to share a different screen if it's okay with you. So this is not included in our application, but it's based on one of the plans in the application. I did submit a screenshot of this in my written testimony from a couple days ago.
Yes, and I had an opportunity to see this. This is from Exhibit 17, I think. It's fine. I did see it in
Okay.
your.
And just to just clarify what's going on, I want to make a clarification. The original exhibit in our application noted that this was a 50-foot buffer here. I conferred with the engineer who drafted the plans. That's an error. So as we said in the application, we're proposing 100-foot buffer from the top of bank, I believe. And I double confirmed that with the guy who drew up the plans. So I want to make sure that that's clear.
And from what I see here, you anticipate putting lot sizes of between 2 and 2.5 acres along this area, that the individual lots will then include the areas that are affected or impacted here as part of the gross size of the lot, but you'll have some type of covenant of non-development through there. Is that your plan?
Exactly. Yeah, just like for that small linear wetland in the west parcel, we developed this with county staff, at least the concept, where this would essentially be a no-build area maintained by the HOA. We have to have an HOA anyway because the streets are proposed to be private. And so this area here, kind of in the darker shade of green, would be prohibited by either county code, our proposed covenants, or both from any development. They would still be part of these larger lots, but again, that would be the case whether we imposed a covenant or not, because to a certain degree, county code would not allow disturbance of this area. Although, as Martha mentioned, we're going 30 feet beyond them. I think, Martha, is it 70 feet, the minimum requirement?
That's what she said.
Yeah, so we're proposing 100 feet and everything below the top of a 20% slope. And so I did my level best. I have limited drawing skills, but I did my level best here to show what that would look like in the dark green. The areas that are lighter green are also forested, but as a practical matter, there's not going to be any access to these. So somebody owning these lots would have to, I guess, sort of bushwhack down through the creek and then get to the other side. There's no vehicular access there, so we don't believe that development, even though it's not specifically limited here, would ever be practical, which is why I'm showing those in lighter green.
Okay, and those hash marked areas behind what look like sort of just placeholder houses, that's your proposed or where you anticipate building your drainage fields.
Right. So those are the septic infiltration fields. And when we laid this out, I asked Jesse to make sure that we could get not only the homes, but the septic systems outside of that 100-foot buffer.
I understand. And it's not technically part of this zoning decision anyway, but let's go forward.
Certainly. Yeah, I just thought I'd give a little color commentary here.
Well, yes, and I think it is relevant, at least, that you're showing that it can be done.
Yeah, and so and then off of Lammer Road, there were some concerns about a lot of new homes. There's actually not very many. I'm not sure of the count here, but I think the proposal is only 4 off of Lammer Road. We don't show example home and septic drain fields on 3 of those lots because the vast majority of those 3 lots off of Lammer Road, with the exception of 1, are not encumbered with this vegetated corridor that we're proposing. So that's really the 3 things I wanted to cover. I think this is a much better plan than what we had approached the county with last year. I am pleased that the county supports it, and I concur with the findings in the staff report. The conditions are amenable to us and we accept them. And unless you have any questions, Mr. Cox, I just want to mention I do have Mike Ard, who's our transportation engineer here, We have Joe from Pacific Habitat Services who worked on the wetland delineation, and then we have Tom Sissel, who's our project engineer. If you have any questions about those 3 areas.
The traffic engineer, just let's get some clarity. Can you put up the shot you had of the entrance, the proposed thing? I read that a little bit differently, and I just, for myself, it's a loose end. Okay, so I saw a left-hand turn lane coming westbound onto your proposed access across from the, I think I have it correctly. We're just looking at a road at a portion of the highway that runs east-west, correct?
Well, no, this actually runs north-south.
Okay, north-south.
Yeah.
I apologize.
So these are through lanes here and here. And Mike, if you're able, why don't you jump online and correct me if I'm wrong at all. But I think these are through lanes here and here. The left turn is it's a southbound left turn lane, right, Mike?
That is correct. Yeah, it's a southbound left turn lane that serves as an access to the new proposed roadway.
Okay, so
it would feed into the site.
So mitigation for that left-hand turn into the access. Now, what about left-hand turn out of the access?
There isn't a requirement for a left turn lane to serve the exit, but as you can see in the diagram, there's road width within the center of the roadway. And because the driveway that's on the opposite side, which is unfortunately not depicted in this image, is an emergency access only, there really won't be queuing or vehicles that are in that median area. So it will be possible for people to make a left turn into the median, stop within the center of the roadway. So that way they're doing what's called a 2-stage left turn. You look for a gap in the northbound traffic stream, you pull into the center of the highway, you look for a gap in the southbound traffic stream from the center, and then join the southbound traffic. So that the presence of that width does make left turns out easier than they would be absent that pocket, but it isn't necessary for operation. And so it isn't something that's a distinct feature or requirement of the mitigation plan.
All right, thank you for clarifying that. I looked at this and it looked like there was a median, some kind of area there, and I was a little confused about that. Then I see where the right-hand turn as you're going northbound on Highway 213 has a deceleration lane is anticipated to directly into that access.
Yeah, it isn't needed for operational reasons, but ODOT does prefer in this case to have a deceleration lane just to make it so that the people who are slowing down to get into this access are not interfering with the flow of through traffic along the highway.
Okay, that makes sense. Thank you for clarifying that. Okay, did the applicant have something more?
Nothing else, Mr. Cox, unless you have questions.
I don't. Thank you very much. I'd like to provide enough opportunities at this time for members of the general public to provide input and comments. Please direct your input and comments to an approval criterion here and use the raise hand feature, and Ms. Reinhardt will
First up, I have Mike Patterson, followed by Paul.
Mike Patterson.
Yes.
Thank you.
And there's no last name for Paul.
All right. Well, let's start with Mr. Patterson, and then we'll we'll give Ms. Paul an opportunity, and we'll learn Paul's last name.
Can you hear me okay?
Yes, sir.
Okay, my name is Mike Patterson. I live at 15017 South Twin Cedars Lane, Oregon City, 97045. Would it be possible for you folks to pull up that last map that we were just going over?
Mr. Stevenson, would you mind putting it back up? Or it's the intersection.
Thank you.
Not sure he's there. Ms. Fritzy, do you have it? You said it was Exhibit 2, page 5, 4 or 5. Right.
I'm looking. I have to scroll
I
through.
don't mean to put you on the spot, but
Nope, that's fine. I have the application open. I just. need
and
to
I
find it.
understand, Mr. Patterson, I like to see diagrams and something to talk about.
That's how I graduated from high school.
Okay. Just yesterday, I'm sure.
Okay, so let's see, is it? Which exhibit number?
He said Exhibit 2, the application, and I really thought he said page either 4 or 5. I didn't exactly write it down, but I was paying attention.
Oh, I think it's this. All right, share screen.
Perfect.
Can you see all the windows that I have open?
And then yes, busy. Exactly, he just zoomed in.
Okay, so at the bottom of this, if it's the same page I'm looking at, it's stating that they want to shut down Mitchell Lane at 213. There's a note there. Right here. Yep.
Right.
Yeah, down a little bit. Right there. The very bottom says close Mitchell at 213. Why are we going to propose that?
The applicant really wants to answer this. Yes, Mr.
Yeah, it was an error and it was taken off on a later copy, and I guess that one didn't get in there.
Okay.
The error, not that it was, we thought ODOT was going to ask for that. And so when we were circulating stuff with ODOT, that was on there for their, and then they said, no, we wouldn't want that. And so the note should be deemed irrelevant. We're not proposing that. In fact, ODOT doesn't want that. So that's not part of the proposal.
Okay. That's good news from my side of the point, because all of us on Mitchell and Twin Cedars several years ago, it is a county-owned road, but not county-maintained, and we all dumped a bunch of money in blacktop on Mitchell Lane and Twin Cedars. So that was a big concern for me and a lot of the neighbors. So
that's on me for getting the wrong file over when I got everything to Garrett and Martha. We all knew that was supposed to be off there. I just got the wrong file.
Okay. That was my main concern.
And thanks for raising that concern, Mr. Patterson. I think I'd already read the ODOT discussion and emails about that, but I didn't ask any clarifying questions about it. Just I had an understanding that there was a controversy about this property using Mitchell Lane to access the Highway 213. Then that was agreed that wouldn't happen. And the last I saw, that access road was not going to be available to these properties except for as an emergency access. And that's so closed to through traffic.
And Mr. Cox, this is Garrett Stevenson. That's correct. I think that's what we represented in writing in the application narrative as well. So I would defer.
That's what I read. Yes. But thank you, Mr. Patterson. Did you have another comment?
Just on the emergency road, can we clarify? So there'll be a lock gate there unless there's an emergency. Is that how that works?
Mr. Sergino?
Yeah, I mean, obviously we haven't designed the subdivision, but that was the conversation with ODOT. They'd have to have a Knox box for access.
Okay.
Okay, so in my notes, it's anticipate locked access gate. All right. All right. Do we have another member of the general public with their hand up to provide comments or testimony?
I have Paul.
Okay, can you hear me?
Yes, sir. And Paul?
Okay, my name is Paul Edgar, 211 Fifth Avenue, Oregon City. I'm on the Community Action Board of Clackamas County, Historic Review Board of Clackamas County, and Veterans Advisory Council for Clackamas County.
Thank you for your service, sir.
Thank you. I have a concern based around the comprehensive plan, and I would love to recommend have some conditions that are associated with housing, Chapter 6 on low income and people of color. We need to have a future availability of housing for affordability for, and the task force on housing needs had suggested that we need these smaller housing units, affordable housing units, expanded availability in the county. And in my trips along 213 over many years, I've always kind of looked at some of that area saying, oh, well, maybe we could have some type of affordable housing that would open the door for home ownership of people of below the medium average income. And that is a formal desire across the board in what we're doing in trying to create new housing opportunities. And so it is my belief that we should dedicate some of this development in a percentage basis for people below the medium average income, and somehow work towards creating more affordable housing opportunities and lots. And some of it is creates the difficulty of these 2-acre or 3-acre parcels, which are needed for septic systems, as I see, and I can understand.
And also for the zone itself,
Yeah.
rural properties in Clackamas County have a minimum lot size of 2 acres generally.
Yeah, and I understand.
Creates an issue.
I see this. It's this conflict between urban and rural, and we're kind of sitting in this place where, though the comprehensive plan is specifically saying we need to address these needs.
You're not alone. You're not alone in your concerns, sir. Middle housing is growing. I see more middle housing projects, and those tend to be urban, of course, because of the lot issue we just described.
Living in Oregon City, we can't create affordable housing with our costs are so high and land is so high in cost that it makes it very, very difficult to fill this gap that that is spelled out as a specific need in the comprehensive plan. And so somehow I believe that we should be trying to look at how do we do this? How can this be done in this development where there is a dedication towards creating affordable housing? And that's my avocation, or what I'm trying to do. I'm at this point in my life, it's all trying to give back to making a better world. So I'm hoping very hard that we can come up with some solutions along that line. And I just see this as a beautiful place where we could be able to do something much like senior housing that I see in Woodburn, where you can do some things which really are open, look good, and the people could have access to a golf course and be healthy. So thank you.
Thank you for your advocacy and for your citizenship, sir. Do we have another member of the general public?
Yes, we have 3 more hands up. I have Tammy Stevens, followed by Diane Rowland, followed by Scott Paskill.
Ms. Stevens?
Good morning. Can you hear me?
Yes. Good morning.
Wonderful. I'm actually here representing the hamlet and CPO of Beaver Creek. And I want to sincerely apologize that you do not have our testimony in your hands, but literally I got home last night from our meeting about 9:30, and I've been pounding away getting ready for today. So I will absolutely submit our letter and our attachments to Martha so that you will have that in our hands. So today's plan is just to read our input from our community.
And in any case, and I'll make an offer about, or a discussion about keeping the record open, but in any case, the record will be open till 4 p.m. today to submit that. But I'll get to the open, if there's an open record period later, but in any case, you can do that until 4 p.m.
Wonderful. Thank you so much, Mr. Cox. Sincerely appreciate it. All right, I'm just going to read all the input we've received. So here we go. It is the Hamlet CPO of Beaver Creek's understanding from the county's transportation department that cities plan and counties respond. Without planning and funding for the infrastructure of inevitable development in rural areas, the proverbial can is continually kicked down the road. As a result, unincorporated issues and concerns fall squarely on the shoulders of CPO and Hamlet directors. Our directors are committed to serving our citizens and the county, and we are here today to provide input as required by State of Oregon's Land Use Rule Number 1, citizen involvement. We sincerely appreciate this opportunity. Since the issuance of this application on August 24th of 2023, our directors have received numerous telephone calls, emails, and letters. Today's input is a culmination of these communications, our board meeting held via Zoom on Thursday, September 21st, and our community meeting, both in person and virtually, last night, Wednesday, September 27th. We clearly understand that this is an application to change zoning. However, it is our experience that a zone change will soon be followed by an application for development. Therefore, after discussing land use proposal Z0277-23-Z to change the zone from Farm Forest 10 acre to rural area 2 acre on 2 separate lots totaling 111 acres, the following input on both the zone change and inevitable development was received. 1. As the result of 2 failing intersections, Highway 213 and Beaver Creek Road and Highway 213 and Redland Road, Highway 213 is congested and unsafe. To permit 55 homes, 10 trips per home per day, totaling 550 additional trips per day, only exacerbates an existing problem. The state of Oregon, Clackamas County, and the city of Oregon City do not have improvements of these failing intersections on their transportation system plans. Until there is a plan and funding, zone changes resulting in extensive development should not be approved. 2, testimony was received by a gentleman who drives a school bus. His concern was the extreme difficulty he has on a daily basis entering Highway 213 as a result of this congestion. 3, Lammer Road was cited as one of the accesses for these lots. Lammer is a narrow, dead-end rural street without lines or shoulders, and is used by citizens to walk their dogs, ride their bicycles, and enjoy a rural, quiet quality of life. Having through traffic utilizing this road without vast improvements to include the line of sight onto Beaver Creek Road is unacceptable. 4, Beaver Creek Road is a market road, and as a result of unplanned development, a high school, bus barn, college, and the county's new transportation building, etc., it is both congested and unsafe. And again, no improvements are planned by any agency. 5, the line of sight from Mitchell Lane looking south is very limited and dangerous. The proposal states that the applicant is working with ODOT on an ingress-egress from Highway 213, but is not approved. Without an approval from ODOT, and the land secured for a southbound turn lane, this zone change should not be considered. 6, if Mitchell Lane is to be used for emergencies only, how would that be managed? And would a right-hand turn lane be constructed? Has this land been acquired for a right-hand turn lane? 7, the transportation study was completed in November of 2011 during a pandemic when traffic levels were lower. A study with recent impacts would provide a more accurate analysis, and without current and accurate information, a zone change should not be.
Mr. Stevens, I think you meant 2021.
Oh, goodness, I sure did. Mr. Cox, thank you.
It was a paying attention still to the hearings officer.
You are really paying attention to this. Thank you. That was a test. Thank you. Okay, and then number 8, the proposal stated that there were no dogami hazards. Yet Dogami's map attached, which will be attached, indicates landslide hazards and landslide inventories in the northeast corner of these lots. This would certainly be discussed during a subdivision application, but brings into question the accuracy of this proposal. 9, Beaver Creek has a park. The Beaver Creek Community Park, located on Leland Road, southeast of these lots. We are very concerned that both development and the manipulation of the existing wetlands on these lots will exacerbate an existing water problem at our park. 10, this 111 acres has been in agricultural production for decades, offering open space, wildlife viewing, and a quiet and rural environment for those living near and driving through the area. To change the zone from Farm Forest 10 acres to rural area 2 acres is not the buffer from city to resource lands that the local citizens expect and desire. It is true that there are numerous homes under 2 acres in the area. However, many were constructed prior to zoning in 1979. Clackamas County's comprehensive plan defines rural lands are exception lands as defined in Oregon Administrative Rule 660-004-005-Pren 1 that are outside urban growth boundaries and unincorporated communities and are suitable for sparse settlement such as small farms, woodlots, and acreage home sites. They lack public facilities or have limited facilities and are not suitable, necessary, or intended for urban, agricultural, or forest use. Also, rural goals to provide a buffer between urban and agricultural or forest uses, to perpetuate the rural atmosphere while maintaining and improving quality of air, water, and land resources, and also to conserve open space and protect wildlife habitat. 11, 10-acre and even 5-acre lots can still offer timber and agricultural uses. However, once a home, driveway, septic system, drain field, backup drain field, and outbuildings, etc., are placed on 2 acres, there is little room for timber and or crops, with the exception of a fruit tree and a few berries. Comparing 10-acre rural lots to a 2-acre rural lot is inappropriate. 12, after reading the planner's report, always an exceptional job, thank you, Martha, the question comes down to, just because we can, should we? Without infrastructure, we believe in the hamlet of Beaver Creek, the answer is no. After a valuable board and community discussion last night, the following motions were made. 1, to recommend to the Clackamas County Hearings Officer to deny approval of a zone change from 10 acres to 2-acre lots. The board vote was 6 in favor, 0 opposed, and 1 abstained. The citizens' vote was 9 in favor, 0 opposed, and 0 abstained. Second motion was to request from the Clackamas County Hearings Officer to hold the record open for an additional 2 weeks, as citizens and directors indicated they have additional information to share. The board vote was 7 in favor, 0 opposed, 0 abstained, and the citizen vote was 7 in favor, 0 opposed, and 0 abstained. We thank you sincerely for providing this opportunity to participate in the Clackamas County land use process, the Hamlet and CPO of Beaver Creek.
Oh, thank you, Ms. Stevens. I missed the very ending, but you were signing off, and I understood. Since you raised the issue of an open record period, let's finish with the general public, and then I'll get to that, but we'll talk about that. Who else has their hand up? And for members of the general public, if you have something new or different to add, please do. But if you are signing in to show your support, for example, to the CPO and Ms. Stevens and what she just said, please indicate that you're just in agreement with the opposition. Or if you're in support, please indicate that and provide some commentary.
I have Diane Rowland.
Okay, are we there?
Yes, good
I'm
morning.
Diane Rowland of Forest Creek Park, property owner for 42 years. At this time, I've seen a lot of change in the cities of Oregon City, Molalla, and Canby. But thanks to the current zoning of this area, since 1980, the proposal has stayed rural, as you know. And other properties have been godfathered in the master statewide plan, and Forest Creek is part of it because the homes were built in the early 70s. The petition was circulated to Forest Creek Park residents, but as time to meet the deadline for submission, we were really only able to get to about 46 homes. But of those 46 homes, we had no opposition to the idea that this zone change should not go through. The petition
Wait a minute,
stated—
let me clarify. I think there was a double negative in there.
Well,
Petition, your petition is in
Opposing
favor
it.
or in opposition?
in opposition.
Okay, thank you.
And it was done prior, to a lot of new information from the county. So with that understanding, this was, but mainly our main concern is the access to Highway 213. If you truly try to use this road on a daily basis, or not even a daily basis, it is a challenge. And more importantly, the Oregon Department of Transportation is not signed off on allowing this new access point. The maps that we saw were kind of fuzzy when this petition was circulated, so it wasn't very clear. But from personal and shared experience here in the park, getting onto this road during the fall and winter months is time consuming. To go north, can be a challenge. Some people have taken as much as 15 minutes to get to Clackamas Community College, which is 1.5 miles away. Going south is even more. Unless somebody lets you in, and these traffic back up for miles, unless somebody lets you in, you're not getting on this road. And so you sit there. And we don't have really a buffer road where you can kind of jump out and wait till, the southbound clears a little bit. You have to wait. On September 9th of this year, we had our 50th anniversary of this founding of this subdivision. 50 years. It's a long time. And it was well developed. It was well attended by the families that were being here from 50 years to newcomers. We're an active community. And during this formal presentation about the park, it really enforced our common values of having trails, access to Beaver Creek, and natural surroundings of the forest and open common areas for all of us to enjoy. We have a lot of common area that we can use that's ours. And the protection of wildlife is important. In the case of the land to the south of us, our concern was shared with how the wetland and Beaver Creek be protected, because the zone change doesn't really obligate them. they're saying a good intent, but you know, it hasn't really been submitted. And so for this reason, we are basically objecting the potential of volume of traffic, because they cited in their paperwork from a trip generator manual, page 42, if they built out 55 dwelling units to the south of us, a weekday traffic could involve 518 trips of cars added to this already congested road at different times of the day. You have to live here to experience it. So that's in conclusion, when this petition was signed by 46 people, that we were opposed. I've gained personally more information now from you, but I'm not sure that that would change a lot of people's minds. Thank you for your time.
Thank you, and thank you for your participation, and I will certainly consider your comments. And as I stated, the record will at a minimum be open till 4 p.m. today, and I will provide a discussion at the end of the general public participation about that. Do we have another person with their hand raised?
I have Scott Paskill, followed by Lori Reinberger.
All right. Thank you.
Good morning. Can you hear me?
Yes, sir.
Hi, my name is Scott Paskill. I'm a property owner at 15743 South Lammer Road.
Yes, sir.
I just wanted to state as a property owner here that we are in agreement with the Beaver Creek CPO and all that Tammy has expanded on. I have personally gone door to door to all the homes along Lammer Road and Camellia, which is the very end of, across Beaver Creek from Lammer. Spoken with all our homeowners up and down the road here the last 2 years as we've been notified of what is going on. Beaver Creek, actual Beaver Creek, as you know, it is a protected, sensitive habitat at the very end of our road. For kids that grew up here many years ago, it used to be a fishing area down there. So we do know there's a fish bearing. It is steep. It's very wooded. There's an old railroad that went through there. So we're very concerned about that development and adding homes onto our street. We do already have a difficult traffic turning from Lammer onto Beaver Creek. It's hazardous every day already turning, and adding more and more cars is a prime concern of all our neighbors on either side of Beaver Creek, whether it's Camellia or Lammer, just because it is difficult. There's lots of accidents or near misses that happen. The homeowner on the corner of Lammer and Beaver Creek, there's so many accidents there. The people that have come at just such close nearbys, their fence is constantly taken out to the point where they've stopped taking out the fence because there's been so many accidents on Beaver Creek right there at the intersection of Lammer. We have a lot of old folks that walk the street daily because it's a nice half-mile road that is steep. They'll come out with their dogs. They already do walk it early in the morning, starting at like 3:30 in the morning. They do wear their safety vests. They're very nice and protective that way, but we do all watch out for them. And, as some of these last folks have mentioned, a lot of these homes were built prior to the 70s. My house was the original homestead on the street, the Watkins estate. The Watkins had 40 acres here. I purchased it from the family, and now we're 6 acres. But Mr. Watkins had built many of these homes, prior to the 70s. And that's why some of these smaller ones, we have very few newer homes here. The newer homes are on the 5 acres. We do have a precedent that's just been set with a lot that was just divided, that was 10 acres, that was divided into 2 5-acre parcels, but those are newer homes. that just happened in the last since 2018 on taking a 10-acre piece and putting the 5-acre piece. So, you know, we're really concerned. I think probably the biggest thing is traffic on Lammer and not having Lammer Road connected to any piece of the other parcel, the other 88 acres that are across the ravine. Giving any access, any additional bridges or traffic that would come from another 50 some odd homes, additional lots, it would be way too much for Lammer and something that we are 100% opposed to. Thus, the 2 separate petitions that I've had signed by all the neighbors up and down our road. So that is our take on it, Lammer. You know, keep the lot sizes and no additional traffic being connected from the other parcel.
Thank you, sir. I'll certainly consider your comments and input this morning.
Thank you, sir. Appreciate it, Carl.
I have Lori Reinberger.
Okay.
This is Steve. This is
Oh.
Steve Reinberger. Lori's sitting here with me. I'm a landowner that lives on 15024 South Twin Cedars Lane, Oregon City, 97045. And I would just like to address the safety of transportation in the area. You all remember 3 years ago when we had forest fires burning in up the Clackamas River. We were in a stage 3 evacuation zone at that time, and we could not get onto Highway 213. We couldn't do it. It was totally blocked up forever. So I'm very concerned about adding 55 new homes, and that traffic congestion would add to what the problem we already have. What happens if a forest fire starts in this? We get a dry year like we had several years ago. A forest fire starts in the subdivisions that we're talking about. What are we going to do? How are we going to get out of there? Is there a plan? I noticed you had a proposal for an emergency evacuation onto Mitchell Lane. How's that going to work? So that's just my biggest worry. I don't want something to happen here like happened in Hawaii, in Maui. I just don't want it to happen. So that's a big concern of ours, and I think everybody has that same concern. And I have not heard anybody address that issue. Thank you.
Thank you, sir. And thank you for your participation. And Ms. Reinberger, do you support the statements that were made by Mr. Steve Reinberger?
I do, and the Hamlin Group. And again, just to reiterate, we have no other exit. We have no back exit, no other roads to get out of our property. We're on the very back edge of Mitchell Lane and Twin Cedars, and there's no other alternative. That's it.
Okay. Thank you. We have another hand up this morning. Okay. I don't see that we have a need for.
I'm sorry, I just had a hand go up.
Oh.
Well, it went back down. It keeps going up and down. I have L. Kimmel.
That is correct, ma'am.
L. Ms. Kimmel, do you go by L?
That's my initial. My name is Lori.
Okay, thank you. Lori or Lauri or E?
Laurie.
Ah, thank you. And what's your address and?
15121 South Dales Avenue.
I'd like to provide you an opportunity for to provide comments as well.
Yes, sir. Please accept my testimony in disagreement with the proposal. These are my qualifications. I had credentials for property management. I served on a HOA board membership board for 6 years, and I also was HOA president. Now, in Exhibit 1, it has the physical description, and it said it's surrounded by churches. That is an
I didn't
embellishment.
catch what you said. You said it was surrounded by what?
Surrounded by churches. That is an embellishment. There is one church in the immediate vicinity. And another church is maybe a half mile. And then where the Beaver Creek store is approximately is approximately 2 miles away. Now, in the traffic report, the person conducting on the count data only did the count during 7 o'clock to 9 o'clock. That is not the peak hours on Highway 213, and 1600 to 1800. Those are not peak hours. Why not did he not do it on a Wednesday, Thursday, or Friday? And I also noticed that if you were going to have access to Beaver Creek Road, you will need a special permit. And the site trips, single family detached homes, no longer 2 cars per household. There are 3 and 4 cars per household. So his traffic study is a little bit skewed. And it did not use the code standard that allows only de minimis traffic impacts on failing intersection. Highway 213 is a failed intersection, and he failed to quantify the traffic volume that is expected to pass through intersection, notwithstanding conditions designed to avoid impact and detriments, and determines a de minimis. Luba ruling 29, 2001. 213 is a egress for a lot of these homes. And Beaver Creek Road is the second egress. As the other gentleman mentioned, during the wildfires, Beaver Creek Road was a parking lot. Highway 213 was a parking lot. I could not get on Beaver Creek Road. I managed to get across Leland Road, Highway 213. Then to get out of this area, because we were in an evacuation 3, I had to go out New Era Road and drop down on 99E. Now, wildfires is a constant and current problem in Oregon, especially in this area. And there is not any plan for evacuation included in this. None. And also, the flag lot proposed that's for Lammer Road needs a special waiver for site distance. In the RA2 diagram status RDS, it states roads would be 30 feet wide. Exhibit 10, traffic study said 50 feet wide. Exhibit 3, 22 feet. This is very confusing. And also in Exhibit 10, southbound 213 left lane, turn lane, and northbound right turn lane. That also is confusing, and it doesn't look possible if you go out and look at the site. Are they going to put a traffic circle like they did in Molalla and take 213 down for 2 months like they did in Molalla? Every time there's building, a lot of times, like in Oregon City near the high school, when they were building the apartments, they shut down Beaver Creek Road with not a clear access. I had to call, and ODOT at the same time was working on 213. We had one lane, and I had to call the commissioner's office and said, hey, we're stuck out here in South County if there's a fire. And one of the commissioners made some phone calls, and they opened up Beaver Creek Road. That's how fragile this is. And
I understand those concerns. When you're trapped and you don't have that many accesses, and they don't coordinate road closures for construction, that's extremely frustrating.
well, this what would happen. And I agree with Miss Stevens said. And the proposed new access is it doesn't look feasible at all. If you travel that road, people go. It may be marked 55 miles per hour. It's 80 miles per hour people have gone. And Beaver Creek Road, the same way. It may be 45. There's not any kind of traffic control. And even with the school, they've changed it so that during when they flash the lights, then you need to go 20 miles per hour.
Exactly.
And the crash data was incomplete. I can testify that I hear fire roll on accidents on 213 very much on Fridays and on weekends. And that crash data was incomplete. And also, let's talk about the wetlands. There hasn't been a wetland environmental impact study, just soil. No study done by Oregon Fish and Wildlife. Sure. And let me tell you, we've had bears in our backyard, coyotes, and anytime there's any type of building, they get flushed out of their habitat. And we've also had cougars also in this area.
I'm going to ask that we direct it to the zoning criteria here. I understand your concerns for the wildlife and the environment there, but that's more there. I wouldn't expect an environmental or wildlife type assessment at this time for a zoning change. It's not part of the criteria.
What about the creek? That's part of the criteria.
It's part of the area being zoned, and it'll have to be accommodated if they push forward with a subdivision application. That would be contingent, of course, on approval of a zone change, I believe. I mean, of course, I suppose they could work for a subdivision without the zone change based on the existing zoning. But all of those that's outside of what we're talking about today, is what I'm saying.
Well, Miss Stevens hit the nail right on the head. She said that zoning change is only a precursor for a development.
Right.
And I'm a Air Force veteran, and I wrote publications in SOPs for civil engineering. And there hasn't been any flood zone study. And BC Beaver Creek floods regularly. They've had to shut down 213 during the floods of 96. They had to shut it down for 2 hours. And the water table is very high, so it flows out when it overflows right on Highway 213. But let's go back to the study on the stormwater facilities. Are there going to be any pumps? It says raw infiltration rates, impacts on surrounding homes. Whenever you're building, you end up changing the flow. That happened on, I have some friends that live on Beaver Creek Road, and when they put in some new homes behind them, the flow of Beaver Creek got redirected, and it changed the flow to their backyard. They can't use their backyard a lot. And then it also mentioned that ditches overflow and during inclement weather. Yeah, that if there was any overflow, it would go into any ditches. And during inclement weather, I can tell you those ditches fill up. They flow over onto the road, and it's a hazard. And we briefly discussed fire. When our development was made, Claremont Water cited that the developer did not have adequate water flow and water pressure. That in a
Are
fire,
you talking about for the emergency equipment, the fire hydrants?
no, we're talking about water pressure. You have to have adequate water pressure to respond to a fire. If you don't have adequate water pressure, you can't save somebody's homes. And in here, it doesn't say if there's going to be any pumps in case of fire to pump up the water pressure. It doesn't state that. And Claremont Water, which is now Clackamas River Water, was very concerned because they basically said the water pressure in our area was not real good, that if fire responded to one home and somebody flushed the toilet, that there wouldn't be enough water pressure. And I didn't see any hydraulic system analysis from
a number of your comments, while very important to development of the property or potential development of the property or new homes, are not directly related to the application I'm actually looking at, which is the zoning change. What I'm going to ask that you do is go ahead and put your concerns in writing. You may already have, and submit them, and I'll consider them as an exhibit. But I want to give people who are waiting for an opportunity here to provide commentary an opportunity to direct that towards the criteria that I'm looking at for approval or not of this application for a zone change. And also provide a discussion of an open record period. So at a minimum, you can provide those written comments by 4 p.m. today, and I believe I'll be extending that open record period so that I will consider any written comment that you provide, and in that way, I'll be able to determine which of those statements actually are directed at an approval criteria for this. And you can certainly, if there is a subsequent application for development of that property, provide additional commentary directed to an application, for example, for development or a subdivision.
Well, I might add that in goal 3, it's the goal is to maintain rural farms, farmland.
Rural properties, yes.
Right. And right now the property is suitable for grazing and the soil type to grow hay. And right now there seems to be a push for residential conversion, which happens. We have farmers just down the road. And what happens is what the farmers stop making the investment in the property. And then there's a downward cycle on farmland. And the farmer sells it, dresses up, the prices go up, putting it up makes it hard for other farmers or existing people to go and farm.
Thank you for your comments, and I will consider them. And if you provide the written statement that I suggested, I'll consider that as well. Ms. Renhard, do we have an additional person with a hand up?
No, we do not.
Okay. I'd like to discuss a couple of things. Did the county or the applicant have something further that they wanted to add And I will suggest that if there is a rebuttal, that could be done in writing. I'm looking for discussion of an open record period as well. There's a request by the CPO for 2 weeks.
Mr. Cox, this is Garrett
Yes.
Stevenson.
Yes.
Yeah, I'm happy to provide any rebuttal in writing. I think it's going to be fairly short and straightforward, but I am concerned about a 2-week open record period. Notice of this has gone out weeks before we've had this hearing, and I'm not convinced that 2 weeks is going to make the record any more poignant than the typical 1-week open record period. So what I would like to do is suggest a 777, which I know you're familiar with, where the record is open for 7 days for anybody to submit any additional testimony, 7 days for anybody to rebut that testimony and evidence, and then 7 days for final written argument.
That's the typical open record period, and it's what I would generally, that's what's required by statute. Is Ms. Stevens still available?
I am here.
Okay. Ms. Stevens, the applicant's correct, or the applicant's representative, that a typical open record period and what's required by statute is 7 weeks for anyone to submit additional materials to the record. And I'll just state what I'm actually required to offer it. Does any party or a member of the audience want an opportunity to provide additional evidence, arguments, or testimony? Does the applicant wish to waive the period for final written argument? Now, what's required is a 7-day period for the submission of additional evidence, arguments, or testimony, then a second day period for any party to provide rebuttal of what's submitted during the first week, and then a last word period for the applicant of 7 weeks. Ms. Stevens, in particular, what is it that, why do you need an additional period beyond the 7 days? The applicant is correct that there has been notice of this.
Absolutely, and I sincerely appreciate your consideration, Mr. Cox. Truly, it was just a timing thing. And unfortunately, this happens more often than you would hope. Our last Hamlet/CPO meeting was at the end of August, literally a day before we received this application. So when that kind of timing happens, we have to sort of scramble and get ready for, as I mentioned, our meeting last night. So sometimes people are not online and reading all of this as we are. And so now that it's gone out into a meeting, which it did last night, I'm pretty confident we're going to see a few more people adding some time or needing some additional time. And you know what? If 1 week is the standard, I think that that's plenty. We can get out on our social media and website that the record's been open for 1 week versus the 2-week requested, and that will certainly help. Again, it was just a meeting problem with the notification, and unfortunately it happens.
Thank you, and I look forward to seeing the comments and materials that are submitted. I am going to keep the record open 7 days from today for the submission of additional materials, including new materials and comments. A second 7-day period for submission of rebuttal to materials that are provided during that first 7 days. So 1 week of new materials, 1 week of any rebuttals regarding those new materials. And then the applicant has a last word, 7 days to submit that related to the materials that are submitted either as evidence or as rebuttal. Any questions about that?
That's just excellent. We'll get that out to our community immediately. Thank you, Mr. Cox.
7. So I want to put a time on that as by 4 p.m. So these are Thursdays. So 7 p.m. 7 days from today, 4 p.m. on that Thursday, then 4 p.m. on the following Thursday, and 4 p.m. on the last Thursday. Let's make sure none of those are actually holidays. pretty sure that Thursdays are not.
Mr. Cox, I agree. I don't see any holidays on those days.
Okay, so I have us finishing the open record period on the 19th.
Yeah, I've got the 5th for the first open record period, the 12th for the second, and the third final written argument due on the 19th.
Okay, and each day by 4 p.m. All right. Is there anything further before I close this hearing, keeping the record open as discussed?
Nothing from the applicant, Mr. Cox. Thank you.
County?
Nothing, thank you.
All right. Well, thank you all for your participation, and I will review and consider all of the materials that are submitted, including anything that is provided during the open record period. I anticipate closing the record on 4 p.m. on the 19th. If the applicant desires to waive that final open record period, that last word period, you can do that by submitting an email to the county and they will inform me of that. All right.
Thank you.
Thank you all.
Thank you.
Thank you.